What happens when the interests of multiple governments appear to outweigh the search for a single missing child? Madeleine McCann vanished in 2007, but what followed was less a race to find her and more a complex game of international strategy between authorities, each seemingly more concerned with controlling the narrative than with achieving justice. Whilst Portugal's initial response was beset by challenges, Germany later appeared to stall on prosecution, and the UK withheld key records from its own allies. Has the fundamental question shifted from who was responsible for Madeleine's disappearance to what systemic forces ensured we might never find out? This is not merely the story of one missing girl. It is a case study in how political pressure, media management, and international diplomacy can obscure the truth beneath layers of bureaucracy. Before we analyze the suspicions in the case, please tell me where you saw this video from. I will read it all and spread it to the world. In the sphere of international criminal investigations, cooperation between nations is often portrayed as seamless and transparent. In the case of Madeleine McCann, a British child who disappeared in Portugal, what unfolded was a fragmented and often contradictory web of three nations, each operating with separate motivations, legal frameworks, and political interests. At its core lies a triangle of jurisdiction: Portugal, where the event occurred; the United Kingdom, the homeland of the victim and her family; and Germany, which later identified the most prominent suspect. 17 years on, despite global attention and millions in public funding, no charges have been filed. The question is increasingly not just who was involved in Madeleine's disappearance, but why these three nations could not, or would not, bring the case to a resolution. Portugal, as the location of the disappearance, held the primary responsibility for the initial investigation. The PJ, its National Criminal Police Force, responded to Apartment 5A of the Ocean Club Resort in Praia da Luz. What they found was not a preserved crime scene, but one that had been compromised. The McCann's friends, resort staff, and others had already moved through the apartment before the police arrived, meaning no physical evidence had been protected and no forensic perimeter established. The scene was irreversibly contaminated. Furthermore, the PJ made no immediate attempt to gather critical forensic evidence. Schematics of the apartment were not drawn, and basic procedures were delayed. The window through which an abductor was alleged to have entered showed no signs of forced entry, had been recently cleaned, and held only Kate McCann's fingerprints. These early failings would come to define Portugal's role. Within a year, after closing the original investigation due to a lack of evidence, Portugal was largely sidelined. Though the Portuguese police retained the core case files, their authority diminished as other countries and media forces shaped the narrative. Whilst Portugal held the ground, the United Kingdom controlled the family, the narrative, and public perception. As British nationals, the McCanns were not just a victim's parents, they were politically protected citizens. The British media, especially the tabloid press, provided extensive and often sympathetic coverage, framing the McCanns as ideal parents struck by tragedy. Behind this, however, was a carefully managed flow of information. The UK Home Office declined to share key materials with the Portuguese investigation. Despite repeated requests, the British government did not grant access to the McCanns' banking records, their mobile phone logs, and, most notably, Madeleine's medical records. The inability to cross-reference such fundamental data hampered any meaningful reconstruction of the events. No public legal justification for this refusal was provided, but the message seemed clear. At a political level, then Prime Minister Gordon Brown personally contacted the Portuguese government, urging them to permit Gerry McCann to release a description of a suspect based on a contentious sighting, a move that bypassed Portuguese police protocols. At the media level, the UK government appointed Clarence Mitchell, a former director of media monitoring at 10 Downing Street, as the McCanns' official spokesperson. His role was not investigative, but narrative-driven, to manage the family's image and shape press coverage. In effect, the McCanns had their own state-backed public relations arm, allowing the UK to assume an outsized influence on the case, whilst withholding the very data that might have helped solve it. In 2020, Germany announced a major development, a new prime suspect, Christian Bruckner, a German national with a criminal record who had lived in the Algarve region. German authorities stated they had reason to believe Madeleine was no longer alive and were treating the case as an investigation into her unlawful death. The world held its breath, but 4 years later, the promised breakthrough has led nowhere. No charges have been filed against Bruckner in connection with Madeleine's disappearance. Despite being imprisoned for a separate serious offense, his role remains speculative. The German prosecutor's office has offered little clarity on the evidence, simply stating there is currently no prospect of prosecution. Instead, Germany has offered publicized searches. In 2023, they conducted a high-profile search near a reservoir in Portugal, and again in 2024, they led a new excavation. Neither yielded any physical evidence, but received heavy international media coverage. This lack of transparency raised questions. Were these genuine investigative efforts or symbolic gestures designed to project an image of progress? Crucially, Germany did not appear to fully coordinate with Portuguese authorities. Despite conducting searches on Portuguese soil, there was no unified task force and no shared forensic oversight. Germany assumed the role of lead investigator, but withheld the critical details that might allow another agency to verify its findings. The core issue with this tripartite arrangement was its complete lack of genuine cooperation. Rather than uniting around a shared goal, each country seemed to treat the Madeleine McCann case as a national dilemma to be managed politically and reputationally. What emerged was not a collaborative pursuit of truth, but a closed circuit of paralyzed bureaucracy. Portugal, having mishandled the initial scene, lost investigative control. The UK, whilst projecting support, ultimately withheld vital records and influenced the media narrative. Germany stepped forward with a high-profile suspect, but has since issued no charges and offered limited transparency. Together, all three nations operated without a unified judicial mechanism, resulting in a fragmented process devoid of central leadership or accountability. Evidence held by each jurisdiction remains isolated. Portuguese police maintain physical files but have little leverage. UK agencies protect data they refuse to share, and German investigators claim authority but offer no resolution. After navigating this intricate maze of national interests, jurisdictional divides, and investigative dead ends, what are we left with? How does this chronicle of political maneuvering and institutional paralysis shape your view of justice on an international scale? Has the story of Madeleine McCann evolved in your mind from the tragedy of a missing child into a broader cautionary tale about the very systems we entrust to protect us? We invite you to share your reflections on where accountability truly lies in a case with so many questions and so few answers. The Madeleine McCann case is not merely a chronicle of one police force's errors or a single flawed decision at a crime scene. It stands as a stark demonstration of systemic failure across multiple governments, seemingly constrained by institutional pride, legal bureaucracy, and political optics. At no point did any of the three nations involved appear to rise above self-interest to forge a unified, transparent path to justice. There is no central court, no joint evidentiary review, and no universal access to timelines, records, or forensic reports. Madeleine's case has become a legal orphan, claimed by all, yet owned by none. Does the ultimate tragedy, then, lie not only in the disappearance of a child, but in the spectacle of three of Europe's most powerful legal systems spending 17 years circling one another, posturing and pointing fingers, whilst the one question that mattered was left unanswered? In most high-profile missing persons cases, the discovery of physical evidence, particularly when reinforced by biological detection, should redirect an investigation with renewed urgency. Yet in the disappearance of Madeleine McCann, even the clearest forensic indicators were seemingly minimized, questioned, or dismissed. The question is why? Was it because they were inaccurate, or because they threatened the dominant narrative that Madeleine was abducted by a stranger, vanishing without a trace? Among the most compelling early developments was the deployment of two highly trained British specialist detection canines, one trained to detect human blood, the other the scent of human decomposition. These dogs, with internationally recognized precision, were used to inspect locations and vehicles connected to the case. Their findings were unambiguous. Both dogs independently alerted in only two places: apartment 5A, where Madeleine was last seen, and a Renault Scenic hire car used by the McCanns several weeks after the disappearance. No alerts were registered in the apartments of the other holiday companions, nor on any vehicles except the one used by the McCanns, and no reaction was noted at the property of Robert Murray, a key suspect at the time. In most criminal investigations, such specificity would warrant immediate and intensive follow-up. But that is not what happened. Rather than being treated as a potential breakthrough, the alerts became a source of discomfort. The McCanns publicly cast doubt on the dog's reliability, with Kate McCann's response raising eyebrows. Did anyone truly believe a dog could detect the scent of decomposition 3 months later from remains that had been so quickly removed? On the surface, it was an attempt to discredit the evidence, but to many, the phrasing itself, by referencing the rapid removal of a body, inadvertently outlined an alternative scenario to abduction. For a parent insisting their daughter was alive, it was an unusually detailed and macabre hypothetical to construct, reflecting what some interpreted as a preemptive defense. Yet more revealing than the reaction was that neither Portuguese nor British authorities treated the dog alerts as central leads. There were no substantial follow-up searches based solely on their findings, and the scent identified in the boot of the hire car was not matched to any known DNA. Years later, Dr. Mark Perlin, a world-renowned forensic expert, offered a potential solution. He proposed reanalyzing the DNA samples using modern computational tools capable of identifying contributors from degraded or complex mixtures. Crucially, he stated he could work from the original DNA codes, not the physical samples, and would do so free of charge. His software, True Allele, had cracked cold cases around the world. In the McCann case, however, his offer was ignored. Neither the McCann family nor the German authorities, who had by then taken over, responded. In a case starved of hard evidence, why would such a low-risk, high-reward opportunity be met with institutional silence? Taken individually, these events may seem inconclusive. Dog alerts are not definitive proof. A statement from a grieving mother may be emotional, and DNA analysis can be ambiguous. Collectively, however, they reveal a pattern. If a piece of evidence supported the abduction theory, it was promoted. If it contradicted it, it was discredited or ignored. Does this suggest an objective search for truth, or does it more closely resemble the careful protection of a narrative? Dr. Perlin's analysis could have clarified the dog's findings, but his offer was met with silence. The official narrative remained fixated on a faceless intruder, a theory that persisted despite a lack of fingerprints, DNA, or credible eyewitnesses. Even inconsistencies in the family's own timeline were attributed to trauma, rather than being explored as indicators of deeper complexity. Perhaps the most troubling implication is what this suggests about the authorities themselves. In a case of this magnitude, one would expect every tool and technology to be pursued. Instead, evidence that contradicted the dominant theory appears to have been systematically downplayed. This is not just about science being missed, it's about how science, when it challenged the pre-established version of events, may have become a liability. In June 2020, the German prosecutor's office announced that Christian Bruckner was the new prime suspect, stating with unusual boldness that they were now treating the case as a murder investigation. For the first time in years, there appeared to be a tangible lead. Yet in the years that followed, nothing happened. No formal charges were filed, no new physical evidence was revealed, and by 2024, 4 years later, Germany had still not moved the case forward in any meaningful legal sense. The same man they placed at the center of an international spotlight remained unindicted. Even as Christian Bruckner approached potential release from prison for unrelated matters, German prosecutors issued a subdued yet revealing statement. There is currently no prospect of a charge being filed. This single sentence created a paradox that sits at the heart of the modern investigation. If Germany had no legal basis to prosecute, why had it seized control of the case so aggressively, bypassing collaboration with Portugal and distancing itself from British authorities? The German legal system is not known for grand public gestures without substance. Its procedures are built on quiet deliberation. Yet in this instance, the process appeared inverted. A suspect was named before a supporting case was made, and public declarations preceded legal indictments. In the 4 years following this designation, Germany undertook 2 large-scale, heavily publicized search operations in Portugal. Were these genuine attempts to find evidence, or were they exercises in public perception management designed to show action where progress had stalled? The first, in 2023, involved a reservoir in the Algarve. The second, in 2024, an excavation in another nearby area. Despite enormous media coverage, with cameras capturing search dogs and drones flying overhead, the outcome was the same. Nothing of significance was recovered. Beneath the dramatic imagery lay an uncomfortable truth. The case remained stagnant. To fully grasp this stagnation, one must examine the geopolitical triangle at play. Portugal, where the crime occurred, has long been sidelined, now playing a secondary role in investigations on its own soil. The United Kingdom has maintained its own parallel investigation, Operation Grange, but shares little forensic data, treating the German effort as an external venture. And Germany remains the only actor asserting prosecutorial dominance without prosecuting, withholding key data, and leaving its supposed partners largely uninformed. This leads to a crucial question. If Germany cannot or will not charge Bruckner, why does it retain such a tight grip on the case? Several unsettling hypotheses emerge. The first is narrative management. By keeping the case open but uncharged, prosecutors preserve the illusion of momentum, distracting from the reality that no one has been held accountable. The second is institutional reputation. Admitting the case has no viable suspect could reflect poorly on Europe's entire criminal justice system, making Bruckner a convenient placeholder for progress. A third is the avoidance of judicial closure. Formally closing the case would mean conceding defeat, whereas keeping it active allows the state to control the narrative. What is most troubling is how the appearance of transparency has replaced real accountability. These periodic flare-ups of activity generate heat, not light. The strategy resembles a public relations operation more than a criminal investigation, keeping the public engaged while postponing the inevitable reckoning. This is not to exonerate Bruckner. His past and his proximity to the area are suspicious. But in any system of justice, a suspect must be charged or cleared. Instead, Bruckner exists in a state of judicial limbo, a kind of Schrödinger's suspect who is simultaneously guilty enough for media headlines but not guilty enough for formal indictment. Compounding this is the absence of any tri-national coordination. Germany acts alone, Portugal defers, and Britain watches. But what if Bruckner is not the person responsible? In that scenario, does Germany's refusal to relinquish control transform from a determined investigation into a form of obstruction, where every year without progress reduces the chance of ever discovering the truth? The German stewardship of the Madeleine McCann case began with a bold promise. But after 4 years without charges, it is time to ask whether this is still a criminal investigation or simply a bureaucratic performance. When 3-year-old Madeleine McCann was reported missing from apartment 5A at the Ocean Club Resort on the evening of May 3, 2007, the urgency was immediate. That urgency, however, never fully translated into investigative action. What followed was a case study in how early-stage failures, both avoidable and systemic, can permanently damage the trajectory of a criminal investigation. Apartment 5A, instead of being preserved as a pristine crime scene, was effectively surrendered. In any missing persons investigation, the initial hours, often called the golden window, are fundamentally important. It is during this period that evidence is at its most pristine, before it can be disturbed by human or environmental factors. Yet, in the case of Madeleine McCann, apartment 5A was never treated as a protected crime scene. From the moment Madeleine was discovered missing at around 10 p.m., no effective perimeter was established. In the hours that followed, it is estimated that over 20 individuals entered and exited the apartment freely. This included the McCann's friends, known as the Tapas 7, Ocean Club resort staff, local neighbors, uniformed officers from the GNR, and later, Portugal's Criminal Investigation Force, the PJ. What happens to an investigation when its single most important location is, from the very beginning, treated not as a crime scene but as a public space? Each entry risked disturbing vital trace evidence. Footprints were overwritten, potential fibers were brushed away, and surfaces were touched without record. A site that should have been under sterile conditions was quickly rendered forensically unusable. Even after the PJ arrived, the forensic protocol was far from standard. There was no thorough collection of fingerprints from the apartment's windows or doors, and common objects like pillows and blankets were not systematically bagged or preserved. Equally problematic was the absence of foundational techniques, such as DNA swabbing from high-touch surfaces or the use of specialist light sources to detect hidden bodily fluids. With the apartment compromised and lacking proper trace preservation, investigators lost the ability to build a basic forensic narrative. Notably, the McCanns themselves were allowed to clean and move around the apartment after the disappearance, and no official log of who entered the scene was maintained. Perhaps the most telling symptom of this disarray was the lack of a detailed crime scene map. In a well-managed case, a diagram recording the position of all furniture, the state of doors and windows, and the placement of personal belongings would be created within hours. In apartment 5A, no such mapping was done until much later, after the scene had already been disturbed. Without this fundamental baseline, how could any theory about entry or exit points ever be reliably tested? Assertions about a possible break-in through the bedroom window, for example, were later challenged, but no physical record existed to verify these claims. Adding to this instability were the inconsistent testimonies from the Tapas 7. During multiple police interviews, their statements varied on crucial points, including the timing of dinner and, most critically, the child checks. There was no clear consensus on who checked on which children or at what time. Jane Tanner reported seeing a man carrying a child at 9:15 p.m. But no one else at the table, seated just meters away, corroborated this. Gerry McCann, who had returned from checking on Madeleine moments before, also did not see this figure. When the only available evidence is human memory, and those memories conflict, where does an investigation turn? Lacking solid forensic ground, the police were forced to rely on these variable statements, but without physical anchors like DNA or fingerprints, their ability to cross-validate was crippled. The cumulative impact of these failures was catastrophic. The original forensic state of apartment 5A was never documented, meaning every major hypothesis, abduction, accident, or a cover-up, lacked a stable foundation of evidence. If an intruder entered, their traces were likely erased. If, as cadaver dogs later suggested, a tragic event had occurred within the apartment, the lack of early sample collection left that possibility unverifiable. International forensic consultants, including British experts from Operation Grange, would later publicly criticize this initial handling of the scene. A senior official described it as a total breakdown of basic protocol. Indeed, once a crime scene has been altered, it can never be returned to its original state, and without that foundation, truth becomes speculation. Apartment 5A was supposed to be the starting point for uncovering what happened to Madeleine McCann. Instead, it became a symbol of systemic collapse, where the most important hours in the case were lost to disorder. Forensic experts now refer to it not just as a missed opportunity, but as a cautionary tale. A child vanished, and the evidence that could have explained how did not vanish with her. The system simply failed to protect it. In most criminal investigations, memory is fluid. Yet in the disappearance of Madeleine McCann, a peculiar anomaly persists. The 7 close friends who dined with Gerry and Kate McCann, collectively known as the Tapas 7, have maintained an almost eerie consistency in their statements since 2007. Not a single one has publicly revised, retracted, or contradicted the core elements of their testimony. But what happens when, in a case full of inconsistencies, the one area of absolute consistency comes from the key witnesses themselves, and that consistency goes entirely untested? A remarkable pattern of institutional passivity has emerged, with Portuguese, British, and German authorities all sidestepping the Tapas 7, effectively shielding the core group of witnesses from the very scrutiny that could unlock the case. David Payne, a senior figure in the group, offered a response that became emblematic of this control. "This is our matter. All comments go through Gerry." Is this the language of solidarity among friends, or does it suggest a more formal, coordinated strategy to control information? The statement stood unchallenged. In 2007, Portuguese police proposed a vital investigative step, a full forensic reenactment of the night in question. The Tapas 7 declined, all of them citing trauma and legal concerns. The request quietly faded. In any other major investigation, would such a refusal from the only witnesses not be met with intense legal scrutiny? Yet again, none came. Fast forward to 2020, and the German investigation into Christian Bruckner, and we find a staggering omission. Not a single member of the Tapas 7 has been formally re-interviewed by German authorities. How can an investigation into a new suspect proceed without re-examining the foundational timeline provided by those present on the night? What if that timeline itself is flawed? And what if the absence of contradictions is not proof of accuracy, but a result of orchestration? For 17 years, this silence has been mistaken for unity, and this unity for innocence. Not one member has ever broken ranks, leaked new information, or admitted to doubts. In high-profile cases, this level of uniform silence is almost unheard of, unless there is a shared interest being guarded. British police labeled them witnesses only. Portuguese police backed off after political pressure, and German prosecutors have never publicly acknowledged the contradictions in their original accounts. What happens to justice when silence becomes a shield, and when 3 governments fail to compel a group of critical witnesses to cooperate fully? At the heart of this case lies a disturbing reality. No one ever forced the Tapas 7 to answer the hard questions. Their unity has been treated as evidence of clarity when, in truth, it may be the most telling clue that something was wrong from the very beginning. This leaves us with one inescapable question, a question that should have been asked years ago. If there is nothing to hide, why has the silence lasted so long? When Madeleine McCann disappeared in 2007, the Portuguese justice system was thrust into an international spotlight. But beneath the media frenzy lay deeper tensions between national sovereignty and foreign influence. Central to this was a series of controversies involving the Portuguese police, rooted in the legacy of an earlier case, the 2004 disappearance of 8-year-old Joana Cipriano. The consequences of that case, and how they were later leveraged, reveal a troubling pattern where institutional failures were both obscured and magnified for strategic ends. In 2004, the Portuguese justice system confronted the disappearance of Joana Cipriano from a village in the Algarve. Her mother and uncle eventually confessed to her murder, but those confessions became highly controversial amid allegations they had been obtained under duress. The mother was photographed with visible facial bruises. Though no widespread criminal convictions against all officers involved were secured, one was convicted for falsifying documents, and the episode cast a shadow over the police force, creating a latent vulnerability that would be exploited just 3 years later. In 2007, as the investigation into Madeleine McCann's disappearance began to consider alternative explanations, including the possibility that she had died in the apartment, A backlash ignited from British media and political channels. But was this renewed focus on a past case a genuine concern for procedural integrity, or was it a strategic tool used to discredit an inconvenient line of inquiry in the present? The earlier Cipriano case was resurrected in full force, with headlines questioning the credibility of the Portuguese police. The effect was immediate. By October 2007, after sustained external pressure, the leadership of the Portuguese investigation was reshuffled. The focus of the inquiry also shifted, and critical early findings, such as the alerts from specialist detection dogs, were minimized in public narratives. At what point does international pressure cease to be a call for accountability and instead become an erosion of a nation's judicial sovereignty? In 2008, a former Portuguese investigator published a book detailing his theory that Madeleine had died in the apartment. The McCann family responded with a libel lawsuit in Portugal, initially winning a court order that banned the book. The matter, however, escalated to the European Court of Human Rights. In a landmark 2021 judgment, the ECHR ruled in favor of the author, affirming his right to freedom of expression under Article 10 of the European Convention on Human Rights. This decision was not an endorsement of one theory over another, but a crucial reaffirmation of procedural fairness. It clarified that state agents, relying on existing case information, retain the right to express professional opinions, even when those views contradict politically accepted narratives. What does it signify when a European court must intervene to protect the free expression of a state's own investigator, highlighting a paradox where a supranational body had to restore a balance that had been lost internally? This external validation from the European Court of Human Rights underscored a critical weakness: the need for stronger internal mechanisms to ensure national institutions do not yield so easily to political pressure. The international dismantling of Portuguese investigative authority had long-lasting effects. Once the credibility of the domestic police was undermined, any inquiry into alternative hypotheses became politically toxic, and state authorities found themselves constrained not by legal principles, but by public relations imperatives. As a result, critical avenues remained unexplored. The Tapas 7 group of friends were never thoroughly re-interviewed by German authorities after 2011. Forensic inconsistencies were sidelined, and requests for a reenactment of the night were refused. The case stalled for years, not because evidence was lacking, but because the system had lost the legitimacy to pursue it without interference. This intersection of cases offers a cautionary tale of how past allegations can be weaponized to destabilize an ongoing investigation, and how a state can lose control of its own legal processes under pressure. The real story is not about one officer's actions, but about how institutional legitimacy can be dismantled by selective scrutiny. In the days following Madeleine McCann's disappearance, a series of highly coordinated actions by British authorities marked the beginning of an unprecedented level of state involvement in a foreign police investigation. Central to this was Clarence Mitchell, whose sudden presence in Praia da Luz raised questions about the real intent behind his assignment. He soon transitioned from a government liaison into the full-time, exclusive media spokesperson for the McCanns, a move that effectively merged the machinery of government communications with the private interests of a family at the center of a criminal investigation. Under his guidance, press interactions were carefully curated and messages were centrally managed. At what point does compassionate support for a family in crisis transition into a state-sponsored information control campaign? The reach of this involvement extended beyond media management. According to multiple reports, Gordon Brown, then Chancellor of the Exchequer, personally contacted high-ranking officials in Portugal. This direct political pressure allegedly played a crucial role in persuading Portuguese authorities to allow Gerry McCann to publicly release a suspect sketch based on the testimony of Jane Tanner. Yet her description of a man carrying a child was vague and conflicted with other witness timelines. Why was a single, uncorroborated, and inconsistent witness account elevated to become a defining feature of the early international narrative? Brown's intervention, presented as empathy, signaled a deeper issue. Where is the line between customary diplomatic support for citizens abroad and overt political interference in a sovereign nation's criminal investigation? What unfolded appeared to be an effort not just to assist, but to steer and shape the flow of events, introducing a new layer of complexity where political optics began to dominate investigative logic. Even more troubling was the British Home Office's reluctance to cooperate fully with Portuguese investigators. As Portuguese investigators worked to reconstruct events, they made formal requests for key records: the McCann's mobile phone activity, their financial transactions, and relevant medical files. When cooperation is standard protocol in international cases, what does a refusal to share such fundamental data signify? The British Home Office either declined or provided selectively redacted information, citing the need to protect personal privacy. This lack of transparency created a one-sided dynamic, hindering a comprehensive inquiry and fostering a perception that British institutions were more concerned with shielding the McCanns than with uncovering objective truth. Perhaps the most defining feature of the early investigation, however, was its rapid internationalization, a process that seemed designed less to broaden the search and more to manage the narrative. Within 72 hours, the McCanns were in the global media spotlight, with high-profile interviews, a worldwide circulation of Madeleine's photograph, and statements of support from political and public figures. But is such an immediate and professionalized global campaign, supported by public relations firms, typical for a missing child case? Or does its very orchestration suggest a preemptive effort to frame the narrative before an investigation could establish the facts? The theory of abduction was assumed from the beginning, long before forensic evidence could confirm or deny it, whilst other possibilities, accidental death or family involvement, were marginalized. This global media strategy produced two lasting effects. Firstly, it exerted immense diplomatic pressure on Portuguese authorities who now found themselves accountable to an international audience. Secondly, it shaped public perception in a way that insulated the McCanns from serious criticism. Any deviation from the abduction story was framed not as investigative prudence, but as an attack on grieving parents. In retrospect, the unprecedented involvement of British political and media figures transformed the Madeleine McCann case from a criminal inquiry into a geopolitical saga. The question remains, was this purely a humanitarian effort, or was it a concerted attempt to control the outcome, both legally and in the court of public opinion? In either scenario, the consequence is clear. The case was never allowed to unfold naturally. Investigators in Portugal were hamstrung, alternative theories were stigmatized, and public discourse was tightly managed. 17 years have passed. Despite waves of media coverage and 3 national law enforcement agencies being involved, the most striking fact remains that no one has ever been charged with Madeleine's disappearance. Not a single individual, whether Robert Murat, Kate and Gerry McCann themselves, or most recently Christian Bruckner, has ever been indicted. The criminal justice process appears to have stalled indefinitely, not from a lack of suspects, but perhaps from a lack of will. Each individual has been scrutinized to varying degrees, yet the system has seemingly found reasons to withhold definitive action in every case. This absence of resolution is no longer a procedural gap. It has become the defining feature of the investigation itself, a prolonged inertia where closure is neither actively pursued nor officially dismissed. We must now examine the status of each key party. Christian Bruckner was publicly named as the prime suspect by German authorities, who claim to have concrete evidence. Yet years later, they quietly admit there is currently no prospect of a charge being filed. 2 highly publicized searches yielded no forensic results, and Bruckner, imprisoned for unrelated offenses, has never been formally interrogated about the case. He remains a suspect in name only, never in law. Kate and Gerry McCann had their arguido status lifted in 2008 and have not been subject to renewed investigation, despite inconsistencies noted in the original case files. Crucially, Portuguese requests for supplementary phone, medical, and financial records have been systematically blocked by the UK Home Office, creating a jurisdictional firewall that has shielded them from deeper forensic reviews. Equally shielded are the 7 friends who dined with the McCanns, the Tapper 7. They refused to participate in a crime scene reconstruction in 2007. And, since 2011, none have been re-interviewed by any law enforcement agency, including the German police currently leading the Bruckner probe. Their accounts have remained perfectly synchronized for 17 years. In any other context, would such a uniform, unchanging group testimony be seen as reliable, or as an anomaly demanding intense scrutiny? Meanwhile, the investigative agencies themselves have retreated. The UK's Operation Grange has transitioned to a purely administrative role. Portugal's Policia Judiciaria has been relegated to a supporting function, and the German prosecution, despite its bold declarations, has made no move toward an indictment. What began as an international search for a child has degraded into bureaucratic theatre. It is tempting to frame the Madeleine McCann case as a tragedy of human error and investigative missteps, but what if it is not a failure? What if the outcome is the result of a decision? Consider the facts. No suspect has been tried, key data was withheld, central witnesses were allowed to refuse cooperation without consequence, and agencies shuffled responsibilities until none bore ultimate accountability. This does not feel like the natural unraveling of a difficult case. It feels more like a quiet agreement, an implicit understanding between institutions that this case is better left unsolved than confronted. Every opportunity to reignite the investigation has been bypassed. Every difficult question has been redirected. 17 years on, the case is not dead because it is old. It is cold because it has been allowed to die. Thanks for watching. How do you feel about these arguments and theories? Does it give you a different perspective on the case? Leave your thoughts in the comments and don't forget to subscribe to the channel to receive the latest notifications.